one to look at these. Elect is also available for questions, these petitions. Please consider that the general register is also available for questions for these petitions, considering for the ones to assess the penalties. So we're going to start with Friends of Matthew Cross School Board 3/2021. Petitioner Matthew Cross. He was assessed about $9,200 in penalties for reports from December 2021 through July 2025. He is the basis that he's claimed that there was an administrative error in the assessment of the penalty. And he has stated that there were several administrative errors, that there were technical issues with email notifications, that there were no prior communications with the general register related to the penalties, and that the penalties may be barred from the statute of limitations, and the remaining penalties would not have occurred in this. The general register and elect have both provided documentation and informed as well. Leave Matthew process counsel that is
Let me, what's your count? Go right ahead, come on up.
Good afternoon. Thank you for being here. It's pretty interesting to be the first time advocating for a statute that just got passed. But so far, I mean, you all look like naturals handling it, so thank you for that. It sounds like you may have already made yourself familiar with the material, but just to be short, Mr. Cross, who cannot be here right now, he may or may not be on the turning in. He's actually on a mission down at El Salvador and may have satellite connection, but I'll be one buck. Anyways, to sum up, Mr. Cross is running for the school board up and running for the first time several years ago, back in 2021. That's when he established his campaign. And at that point, that's where and then he collected all the money initially. They ran the election, got elected, did not solicit or issue any more payments after that point. But then what happened is that they never got any further notices about, they didn't know that they needed to make any updates at that point, to be honest, for these periodic ones. And they were never asked to make any updates by the local registrar's office. And so they were long, comes time for this next round of elections. They go on to make sure all their financial documents and all the rest of that are up to date and freshen up the registrar's office. And they get notices that there are some late filings. He goes to fix that. He fixes all these things, makes sure everything gets brought up to date, tries to just make sure that the filings are safe. The next day, he gets notified by the registrar that they're fining him for $9,200 for late filings, going back several years. As I summarize it here, my understanding is that he then went to the registrar's office. Now, this is hearsay of hearsay at this point for me, so take that with a grain of salt. But he went to the registrar's office, and it seemed that she was under some type of impression that she basically had to issue these fines and that she didn't have any discretion to address any of the tardiness or any of the other arguments, and that we had to bring it up. I'm not saying whether that's right or wrong, but that's one of the reasons why we're here. So if you look at these fines, we have several years worth of them. The statute of limitations is pretty clear that it's 1 year from date of discovery if you have some type of hidden issue, and then but no greater than 3 years period from the date of the violation. Because the nature of these are that they're late or missing, I would say that you would know immediately whether they're late or missing. It wouldn't be when you filed the update, it would be that these were due on a certain date. There was no report there. That's when it was due. So the bulk of these, $5,200 of those fines are well outside the statute of limitations at that point. And then, as I point out for the remaining violations, the thing is that we had a few of these violations where the deadlines passed this year or within the last year. And like I said, as soon as he realized that there was an issue, Mr. Frost immediately went and fixed it, and he opened up to make sure that he was up to date. And I know that if he had been told within the if the registrar had brought it to his attention sooner, either through a letter or something like that, or sometimes had some interactions, he was practically testing the subsequent fines. So Mr. Cross is very apologetic. I've had some conversations with him about this. He really does believe in transparency. He really appreciates what the registrar and what these laws are here for. It was, I believe, a very honest mistake, and he and his wife put some measures in place to make sure that these things happen again, which was not a long time.
And your name, sir?
My name is Polly Gwynn, Tolley. My middle name.
G.
Gwinn.
Thanks.
Here it's found me.
Oh, I should read it. Thanks. All right, any members have any?
Mr. Chairman, so I'm just looking past here, and it looks like you filed 4 times late. Or Mr. Cross filed 4 times late, and then just stopped filing. So you had to know it wasn't just a one-time deal, right?
So my understanding for those was that they had some technical issues.
I'm not debating whether they're late. I'm just saying that he was filing and he knew that he had to file, and then he
Yes.
just stopped filing.
Yes, I believe that what's happening is that for some reason that he was not getting the common updates anymore at that point. So he was getting some of these notices to go and update his information. That was my understanding of there are some technical breakdowns. One of the issues was that it appears that his email, so they had like for their IT at his job, or he's a pastor at a church, and so he uses his work email for these things. It appears that it was no longer forwarding emails. Like at some point there was a domain issue, and so he wasn't getting common issues or common updates at that point. But as I understand it, some of these.
Right. So, having filed a number of these, we didn't rely on notice that we had to do it. I mean, we knew that that was part of being in office. So, saying that the explanation is that I wasn't notified, I'm not sure. We think that that's valid.
Well, so I don't think that it would be a defense against, say, like a first time. I don't think it'd be a defense against it. Like I don't think it'd be a good pattern to develop here. I think that the issue here, though, is that we have $9,000. I mean, the statute says that the majority of these are well outside the statute of limitations, as far as I interpret it. I would say that when you have a pattern and then it's not ever enforced for a long time and you don't get any notice, I do think that that causes an issue. I would say it's the same thing as, I don't know, I've had to defend and prosecute speeding tickets before, and if you had a police officer who was tracking someone over and over and over again, and then tried to bring up all the tickets for every single speeding violation, even though they only got them on the last one, that's not really how the best way to get on it. And that's why I would say it's an administrative error is that the statute does say that within 90 days of a violation, these are supposed to be brought up and addressed with the Commonwealth's attorney going, the local Commonwealth's attorney going and collecting the fine amount. That wasn't done for anything for that matter. So again, I'm not saying that, again, Mr. Cross is not saying that, you know, this is the way things should be done, but we do think that because of the fact that this is an issue with the administration of the actual enforcement portion of it, the current fine, the fine as he received it is very much excessive. And I think that that's why what we're asking for is we're asking for the $500 fine for a first-time party use offense within this.
I'm not, Senator Peters.
Thank you, Mr. Chair. So I'm reading this code section, and it says a prosecution for any violation of the Campaign Finance Disclosure Act 24.2-945 at sequence shall commence within 1 year of the discovery of the offense, but in no case more than 3 years after the date of the commission of the offense. It seems to me that the discovery, of course, these are public filings, so the discovery should be the date which it was missed, right?
Yes. That's yes.
I'm not your honor. I make too much money.
Yeah.
Let me ask you this. is there, I mean, is there anybody here from Rockingham County Registrar's Office to explain why there was this gap in time and enforcement?
Lisa Gooden, she's on.
Okay. So I guess that's my question, because
Okay,
I
let's
think
hear
the
from-
statute of limitations target is
I
pretty
think
obvious.
it's entirely appropriate to hear from registrar at this point.
Lisa, are you available?
Yes. Can you hear me? Can you hear me?
Yes, yes.
Okay.
So Mr. Frost's campaign finance person noted that the change took effect April 16th of 2023, but no amendment was filed until 10/27/2025. So there was a lapse from when that change was noted in communication to elect. But no amendment was filed on behalf of the Cross campaign until 10/27/2025.
Okay, so follow-up question.
Go ahead.
So what's the significance of what you just told me? Were you not aware that he was a candidate?
No, that's not the case. It's just his campaign treasurer had noted that there was a change effective April 16th of 2023, but then nothing was filed pertaining to that amendment until just this fall, 10/27 of 2025.
One more follow-up question. So ma'am, the statute says that you have to bring an action to collect this fine within 1 year of the discovery of the offense. And some of these offenses date back to 2021 or early 2022. What prevented you all from knowing that there was an offense?
If I'm not mistaken, I think Ms. Alexander at the state had attempted to reach out to the Cross campaign, but no response was received by that campaign.
Thank you.
Yeah, I have a question.
Vice Chairman Davis.
I guess I have a question from her and then from the state, because what is your response? Are you the registrar, and have you been the registrar during this whole period of time?
Yes,
Basically 2027 to 2027, whatever it is, the period that we're talking about here. Have you have been the registrar?
yes,
So
ma'am.
So what has been your response to trying to collect their penalty? Do you have a record of you're trying to reach this campaign and they not responding?
I have some records, yes, here in front of me.
You actually submitted a request, letting us know.
I would like to know real quick, as I have not seen any of that, whatever they provided to the state.
I need some questions from the state.
Yes.
Let's hear from elect.
Do you have a question,
What I'm hearing from the registrar is that that she's now saying that the state board of elections was handling something as though it was their responsibility. Now we're back at the state level, that the state board was responsible for requesting these penalties.
So any communications that we have with Mr. Cross was shared within board papers. So that's all the information that we had, and as well as anything referencing the penalty working with the general register was also in the board's papers as well. But the general registers are legally supposed to assess penalties.
Are you hearing me? That what I'm hearing is that you would have had the responsibility to ensure that this person complied by notifying him within a certain period of time, as I say, I got it for you, is Senator Stevenson is saying, is asked the question.
Discovery.
He's showing that the record said was within 90 days after you find out or whatever, within a year's period of time, we're talking, from what you're saying is the 23rd to the 27th of, am I getting this right? It just seems like something's off here, but during this period of time that this person is being held accountable, you are assuming that the state had responsibility for doing this? The notification?
The state had sent some communication through email to Mr. Cross.
I want to know what you did at the local.
I followed through after I learned of the delay.
May I speak?
So, yeah, are you done?
I don't think you've answered my question. Just simply tell me, what is your responsibility, you directly related to receiving the outstanding penalty? And notifying the candidates that they had an outstanding penalty. Or collecting the money for the coffers, for the local coffers.
I mean, back in July, there was information that was sent to me outlining the time frame from February of 2021 through November 2025 about the status of Mr. Cross's campaign. So he was late in October of 2021. And that's kind of when the penalties began.
So, you're gonna plead ignorance.
I'm just,
Better.
I think we could spend a lot of time on this, but I think assuming this is a statute, we have to the court, it is. Violations 1 through 8 are just, and I think that's really not, that's beyond dispute, I think. 9 through, excuse me, I guess 1 through 7 are timed out. Do I have that correct?
Yes.
Okay. Violations 8 through 10, I think the argument's slightly different, that you have a 90-day period in which to bring this to the attention of the candidate. Have the Commonwealth's attorney, for example, issue a summons, correct?
Basically, yeah, it's within 90 days of the Commonwealth's attorney, and I can also represent that did not happen.
And I understand that, and because of that, he never made the filings that he was supposed to. Yes. So I think 1 through 7, again, that's just, there's no legal. 8 through 10 is a little bit of a closer call, but I think it is true that because he didn't get notified, he really wasn't on notice that this was an ongoing requirement. And you can make an argument that he was because he's a candidate. I guess what I would certainly take 1 through 7 are waived at this point legally. 8 through 10, I think, is a tougher call. 8 through 10, 11 is due.
Yes, Your Honor, and we're not contesting that. We really want to make sure that we're back on the right foot on
I
that.
there's any dispute that 11 is due. My recommendation would be is that we dismiss all these fines except the last one, which is number 11, which is a $1,000 fine.
But yeah,
Yes, ma'am.
so you had made comments and then made a motion.
I will make a motion.
Okay, you're not supposed to speak and then make until somebody else speaks.
I withdraw any motion. I just made a comment.
Vice Chairman Dance.
I have a sense of unreadiness, and I would like to have some input from guidance from state representatives as far as how this statutes and how we should look at this.
So, we can't speak as far as the statute of limitations is concerned. Just legally, we're supposed to assess the penalties. That's just how the law's laid out for us. As for any other guidance and we actually answer questions that you have regarding this petition, but I mean, ultimately, it's up to your discretion, if you find that there's good cause.
So if we were to look at, eliminating, those, suggestions from Senator Peterson, and we were to address the other, what would that equate to in penalties? What would that option be?
So if we're eliminating, you said what, the first 9 or the
No.
first,
1 through 7 is beyond the statute.
so we're down to,
8, 9, and 10, which is 3,000, and then the 25 will be 715.
so the last 4,000 or the last 3,000, sorry.
The last 4,000.
Okay, last 4,000. I mean, if that's what you would like to focus on, then that's within your discretion.
Mr. Chairman, I'd like to make a motion.
You want to refer to Senator Peterson?
No, that's all right. You do your
Go
thing.
right ahead, Delegate Stout.
And you got me confused. Would like to, grant relief for this and to the tune of a fine of $1,000.
Second.
With that, is a motion properly seconded? I do have one quick question.
Yes.
Is it factual that if this registrar could have any one of these years sent this to the Commonwealth's attorney?
Well, it would have needed to be assessed first before it would be sent to the Commonwealth's attorney. There's a period in which that they have to either pay. Now there's a period in which they can appeal, but yeah, it's assessing the penalty first, then they can send it to the
So
Commonwealth.
after much discussion, there is a properly seconded motion for a $1,000 penalty for this. Any discussion?
I'm in agreement, I haven't voted yet, but what I see is that there are some errors on both sides, or there should have been some more action on both sides of this. Now, those of us that have served and we tried to do the best we could as far as reporting, we didn't want to get into penalties, so we stayed on top of it. So that's one side, but the other arm is there is a requirement, if you need to knock the hammer on me, you knock the hammer on me, so that there's two sides to this. So I'm agreeing with him.
Speak in favor of the motion.
I'm speaking in favor of the motion.
Thank you. Any further discussion? Call the roll.
Chairman O'Bannon.
Aye.
Vice Chair Dance.
Aye.
Dr. Stalling.
Aye.
Mr. Peterson.
Aye.
Secretary Alves.
Well, I think that's enough.
There you go.
Okay, so that concludes that petition. Now we're moving on